Good morning. I'm excited to be here and to talk to you about how to deal with corporate representatives because those are the witnesses you want to call first. You want to call them adverse. You want to prove your case through them. You want to show how bad the company is through its own employees. And so there's just a couple of tips and techniques I hope that you'll learn today about how to do better with corporate representative depositions. All right, so let me get started. Let me share my screen. And I'm going to talk about adding some spice to the cross-examination of corporate representatives. All right. So let's just a little roadmap. When you're sitting down to think about what you're going to be doing with the corporate representative, I want you to think about the 3 Ps. Proof. What are you trying to prove with this witness and how are you going to do it? Do you have the tools, the documents, the visuals to really prove the points that you want to make? Prepare, uncover the evidence. If you don't have enough documents, go get more. Get clips from other people's depositions ready that you can play to them. And then last, how are you going to present this story? So the 3 Ps, do I have the proof? How am I all prepared? And how do I present this story at trial? And what am I going to do in the deposition that's going to make this a really compelling deposition to play? All right. So 5 take-home tips, and that's what I hope I'll get to give you 5 things that you can take home and start using immediately. The first tip is documents. With corporate representatives, the number one way to prepare and to be ready to block them. Remember, the corporate representative is there to give the message of the company. They don't want to hear your message. They don't want to agree with you. They don't want to prove up your case. But the way to make sure that they do is with documents, because every time they try to run away from you and say something different, you've got a document to stop them. So corporate documents are the most important thing to have and to have reviewed before you start taking the corporate rep depositions. That's where you're going to find the smoking guns. So you start with the request for production. Remember, a company is not motivated to give you their best documents in the first round. They're motivated to think of all kinds of objections and all kinds of things that would block you from getting the documents. So a request for production to the company for the documents you need for your corporate rep depo, you need to request them. You need to then do a meet and confer. You need to move to compel. You need to go through every step because they legitimately can keep those documents from you if you haven't done what you need to do, which is protect your client's right to get the documents. So back in the good old days, this is what document production looked like. You know, there were warehouses and there were boxes and there were papers. I mean, this is a picture of us from 20 years ago, sitting in a room. The drug company would wheel in these carts filled with boxes, and me and my entire trial team would sit and we'd go through page after page after page of documents day after day. Those days are gone. Current productions are now on hard drives and web-based platforms. And that sounds easy because you can sit at home and do it, from your recliner with your fuzzy slippers on. But do you really take the time out of your day to sit and go through the documents page by page, or do really comprehensive word searches and then look at all the documents the word searches come up with? Because without that, almost the good old days were better, where we had to sit in a room and we were forced to page through every page. Now you've got to really make yourself. You've got to take time out of your day to make this happen. This is one of our more recent productions where we hired a bunch of law students. We set up these folding tables with computers, and we had law students work almost around the clock because some wanted to work at night and some wanted to work in the morning, going through the corporate documents in order to get ready to start our corporate rep depositions. So whether you're having your documents reviewed by the legal team, whether you're having it reviewed by law students or law clerks, whether you're outsourcing it to be done in Pakistan or India, as many big litigations are doing, the most important thing is you must look at the documents. And you have to look at the documents and select the relevant pages that you think the jury would ever need to see and that you think you might need to use in a deposition. You've got to create a timeline, because the documents are produced in custodial files. Some of them don't have dates, but somewhere in the document is a sense of what the date is. You've got to create a timeline where you put these documents back into date order to understand what the company knew when they said X. If they represent X, but they knew Y, that's a really interesting juxtaposition for the jury that you're going to want to prove up at deposition. You're going to want to subjectively summarize and code each document. You want to look at each document and actually summarize and code them so that you can be sure that you understand what is relevant and good about that document in a very searchable way, that you can find it again, you can theme it. And then after you select the relevant pages, you create your timeline and you date order every document. You've summarized and coded each document. Then you want to create a master exhibit list, and you want to give your documents that you know you're going to use the top 50, 100, 350, 500, depending on your case. You want to create a master exhibit list where you number them and you use the same number for that document in every deposition. That way, if you use a really great document through 3 or 4 depositions, every time you play that snippet of the deposition, it's the exact same exhibit number, and it's the same exhibit number the jury has gotten used to. And so they can see that trend through the depositions. You don't want it to be deposition 4 in one depo and deposition 12, deposition exhibit 12 in the other, and 52, and then it be 185 at trial. You want to have some consistency so that the jury can follow along with you. All right. Why are documents important? This is I'll take you through the reason why documents are so important. Breast implant litigation, after probably 2 or 3 years of reviewing documents, suddenly a document was found, a Dow Corning document, which showed that when they did the Beagle dog testing, it showed up with issues. They put the little baby implants in the Beagle dogs, and the Beagle dogs showed up with so many issues. There was handwriting on the top of the document that said, "We have too much invested. Kill all the dogs, just destroy them." And that's what they did, is they killed the dogs, they killed the study, they killed the data, they killed the information. It never got out to the public. The "kill all the dogs" memo became a huge piss off anger factor for jurors, as they saw this company that didn't care what the data showed, was happy to lie and just destroy the data, including destroying living beings, dogs. So that's why documents are so important. Hormone therapy litigation, which I did for years, it was a combination of 2 drugs being used together to treat women in menopause for menopausal symptoms. And I'm going to show you just a few of the documents, some of the key hot documents from the hormone therapy litigation, so you can appreciate how important it is to get through this process of document production. I remember it was Christmas morning. I got up as I was waiting for the kids to have their shower so we could go to, my mom's house for open presents. I was just looking through a few documents, that kind of gets addictive when you've got them on your computer and you can keep doing page down, and you're sort of mining for gold. You're not sure what you're going to find. Christmas morning, I found this document. It was about an outside group that had approached Wyeth about doing a breast cancer study involving hormone therapy. Exactly the kind of study we had said the company should have done before they started selling this drug to millions and millions of women. They should have studied whether it could cause breast cancer. And here's what the document said. ECOG had approached them to request just drug, not even money, to do this study. And after some time were rejected, as is customary, apparently, for studies involving breast cancer. Wow. So I now have document proof that Wyeth didn't want to ever understand breast cancer, didn't want to get to the bottom of the breast cancer issue, didn't want to fund a study that would look at breast cancer. Powerful, powerful document. Here's another one, myths and misperceptions. We found this, in the middle of a smorgasbord of irrelevant documents. You suddenly find the gold where they're going to start this marketing campaign where they're going to bust the myths and misperceptions about hormone replacement therapy. And it says that to join their coalition of myths and misperceptions, you have to be willing to take the position that hormone therapy does not cause breast cancer. So you can't get funding and you can't be a part of the the cool kids club unless you agree up front that hormone therapy does not cause breast cancer. Very powerful document. So documents. It takes work. You've got to get them. You've got to review them. You've got to code them. You've got to understand them. You've got to put them in chronological order. You've got to number them. But wow, that's the key to a corporate rep depot. All right, tip number 2, misconduct and motive. You want to be always looking to tell the jury that this is not something that happened by accident. It wasn't by accident that this corporation did the bad thing. It was on purpose, because on purpose feels like negligence and gross negligence. How do we prove on purpose? On purpose is either active misconduct, where they're actively lying, deceit, hiding, or misconduct by omission, where they knew that they should be doing the right thing and they just didn't put the steps in place. They didn't put the safety rules in place to make sure that they were doing the right thing. All right, the Ford Pinto case. They had the gas tank above the wheel so that when the car was hit from behind, even just a little bit, it would explode and everybody in the car would burn up. There was huge explosions. The Ford Pinto became sort of a joke because they had done this stupid design of putting the gas tank back there where just a tap would explode the car. And, the document that won that case was this document. There was a benefit and cost analysis done relating to moving that fuel tank. Should they move the fuel tank? And the unit cost was $11 per car. And they estimated how many times they would have to pay issues. And so the unit cost per car to recall every car would be $137 million. But if they felt like they would only spend $49.5 million if they only killed 80 people and had only 180 serious burn injuries. So they actually did a calculation, what it would cost to move the gas tank versus what it would cost to pay killing people. That is a powerful document. And what happens with these powerful documents is you get the jurors immediately enraptured, immediately angry at the defendant, immediately on the soapbox of this is a bad company. And that's why finding the documents will help you prove the misconduct and the motive. Okay, let me get back to my documents. And here we go. So this is an example of a company that knew about the problem, knew there was a gas tank in the wrong place, deliberately ignored an opportunity to remedy, knew they could move it, but it would cost money. And the reason they didn't do the right thing was money, was profits. Wow, very powerful. Let's look at cigarettes. Cigarettes in 1994, the CEOs of the 7 largest tobacco companies testified before Congress as follows.
Let me begin my questioning on the matter of whether or not nicotine is addictive. Let me ask you first, and I'd like to just go down the row, whether each of you believes that nicotine is not addictive. I heard virtually all of you touch on it, and just yes or no. Do you believe nicotine is not addictive?
I believe nicotine is not addictive, yes.
Mr. Johnston.
Congressman, cigarettes and nicotine clearly do not meet the classic definitions of addiction. There is no intoxication.
We'll take that as a no, and again, time is short. If you could just, I think each of you believe nicotine is not addictive. We just would like to have this for the record.
I don't believe that nicotine or our products are addictive.
I believe nicotine is not addictive.
I believe that nicotine is not addictive.
I believe that nicotine is not addictive.
And I too believe that nicotine is not addictive.
Wow. Okay. So here we have the corporate message. Corporate message is nicotine is not addictive. You can't cross these people. You can't cross-examine the CEOs or the employees of these companies without documents because they get to just say it. They get to say our company's a good company. Nicotine is not addictive, but go into their documents and you'll prove the misconduct and the motive. 20 years before, when we got the documents, when people started looking at the documents, plaintiffs' lawyers proved that in 1974, they knew very few consumers are aware of the effects of nicotine, i.e., its addictive nature, and that nicotine is a poison. Wow. 11 years before they stood in front of Congress, 1983, nicotine is the addicting agent in cigarettes. So here's proof. They knew about the problems. They ignored opportunities to warn about the problems. And then look at Camel. They knew when they put a kid's cartoon on their cigarettes, they went from 1 to 31% increase in profits in 3 years. They knew teens represent tomorrow's cigarette business, that the 14 to 24 age group, when they mature, they will account for a key share of the total cigarette volume for at least the next 24 years. If we hook them young, we're going to keep them as a long-term user and make a ton of money. All we will need then is a larger bag to carry the money to the bank. What's that? The financial motive. So now you've proven up all three things. Knew there was a problem, ignored opportunities to remedy or opportunities to warn, financial motive. Resolin litigation, it was a diabetes drug, fast tracked to market that ended up being liver toxic, blew out your liver. This was a drug I did for years. And here's some of the documents we found. Celebrate Resolin's $1 billion bash. What have I found? Financial motive. This is a big moneymaker for the company and they can't afford for it to go bad. Internal document. They were tracking their monthly sales divided by the deaths. People who had died of liver failure. They're tracking it. How much are we selling? How many people are we killing? Wow. We knew that Warner Lambert sold Resolin in North America, and Glaxo Wellcome sold the same drug in England. Glaxo Wellcome, when they looked at all the study data, said, you know what, this drug is too liver toxic. We're taking it off the market. We're not selling it anymore. Internal document of Warner Lambert discussing the actions of Glaxo Wellcome. They said the product was not going to make a lot of money in the UK. It was looking to be a commercial disappointment. Hence, it was easy for that company to take the high road on safety. Their decision to pull the plug and not sell this drug anymore has to be seen in this light. Wow, what is that telling the jury? This is a company that only cares about money. They don't think they can take the high road on safety because they're making $1 billion. You know, and then great slide from one of their very senior managers. If we pull this off, we'll eat like kings. Need I say more?
Yeah, the conduct of Warner Lambert was interesting. They lied, they deceived. They were less than forthright with information. So I think the takeaway from that is, I guess, they realized that in the early 90s or mid 90s, I guess it was, that they were going to be convicted for some lies and whatnot to the FDA. And they were certainly convicted of that, but apparently they didn't learn their lesson because they certainly did it again. They falsified records, intentionally knew that they had to get the drug on the market quickly because it was going to be one of their cash cows. I think they were in some financial turmoil. They needed Resolin to be a cash profit-making opportunity for them.
So that sums it up. I mean, after we won this trial, I did a quick interview with one of the jury foreperson. And you can see everything that we were trying to, all of our messages landed. All of our motive messages landed. All of our misconduct and gross negligence messages landed. Really important. Knew about the problems, ignored opportunities to remedy, financial motive. All right. Tip number 3, victory with visuals. You know, there are 3 learning styles. They are visual learners, auditory learners, tactile learners. I am a visual learner. I'm like 60% of the world. I learn when you show it to me. And the retention rates are so much higher for everybody. If I just tell you something, 3 hours later, you'll remember 25% of it. 3 days later, 10%. If I just let you read it, you'll remember it 70% after 3 hours, again, 10% after 3 days. But if I tell you and I show you, if I let you read it and I talk to you about it, if I let you see it and hear it, 80% after 3 hours, 65% after 3 days. When is our jury deliberating? 3 days from now, 8 days from now, 6 days from now. We have got to figure out how to get them to retain the information. So you must be visual. Otherwise, this is your jury. They're asleep. They don't care. So let me give you an example. Always think about being visual in your depositions. Always think about how can I visually describe this, show this, so that when this deposition is played, the jury will see something that's visually interesting. I'm currently in the middle of this trial. Amazing, isn't it? Back in trial after the pandemic. We are in a COVID protocol trial in Costa Mesa, Orange County, California. It's on the drowning of a 6-year-old child at Howard Johnson's water park. Howard Johnson Hotel had a children's playground and water park, and this child drowned in the hot tub. So this is the Howard Johnsons. I'm talking to the water park supervisor about the slide attendant and why the pool attendant that they had out there did not see this child face down in the hot tub. And you'll see I'm being visual because I'm on Zoom, which is easy because I've shared my screen on Zoom. I've got the witness on one side. I've got my photograph that I want the witness to talk about. And now I'm giving the jury a visually interesting deposition. So there is a completely open line of vision for the person at the top of the slide to the hot tub.
Correct.
Easy. Zoom makes it so easy to be more visual. All right, tip number 4, dynamic depositions. If you're going to do a corporate rep deposition and you think you're going to have to use it at trial, you want it to be a wow. You want it to be dynamic. You don't want it to be this. This is really boring. I mean, can you imagine 2 hours of this? You'd be snoozing too if you were the jury. So how to be visual, how to be boldly visual in depositions. First of all, think about writing on the wall, movement, cementing what the witness is saying by demonstrating it. Writing it out is so effective. You can use it at trial. You can use it in a deposition. It helps make the witness understand what you think is important about what they're saying, helps them track where you're going. This is an example from Boeing cases. We represent a whole series of flight attendants, and pilots that have sued Boeing for inhaling toxic air in the cabin, where the air that's inside the cabin gets contaminated because of a design defect from Boeing. The way they made their planes allows the toxic chemicals from the engines of the plane to enter into the cabin, and it can impact the crew, the passengers, the pilots. So this is a deposition of a defense medical exam. My clients were sent to see the defense medical exam, and I'm just pointing out the flaws in a defense medical exam, that this is not a treating doctor. And your job in these medical evaluations is to evaluate injured workers, not on their behalf, right? They didn't choose to come see you.
Correct. I'm not a treating physician.
Right. They're being required to come see you.
Yes.
Now, so in these medical evaluations, you are not their doctor, right? That's pretty clear. They're not coming to see you because you are their doctor.
Yes, it's called an independent medical evaluation.
You are not treating them, right? But nothing about what you do is going to make them feel better.
I don't know whether it makes them feel better or not. If I give them an impairment rating that they agree with, they may feel better about that.
All right, let me ask a better question then. Nothing you do is going to prescribe any medical treatment for these patients.
That's correct. I do not have a treating relationship.
They are not your patient, right?
That's correct.
All right, these people are So you kind of get the idea. Now, if I'm watching this as a jury, as a juror a year later, it's interesting. I can see me moving. I can see him. I can sort of see the emphasis of what, what they're looking at. I can see the visual, and I'm much more interesting than just the plain headshot. All right. So how do you do this? Well, it's called split screen editing. And I would really encourage you to think about using it because you want to recreate the same experience that the jury would have if the person came live, and to have the jury have the same attention span. You're in pursuit of a longer attention span. CNN knows it. I mean, you don't see just Jake Tapper's head. You don't see just General Powell's head. You see both so that you can see the interaction. They're not in the same room. And in Zoom, we're not in the same room. And even if we're in a deposition or we are in the same room, the jury doesn't get to see that again. So you want to be able to see both the questioner and the witness. So this is an example case. We're working on a serious traumatic brain injury case. It's a result of a minor impact rear end collision. And you'll sort of see the idea of split screen editing. So we could take, this is the president of the company, corporate representative. We could take a picture, the whole video just like this, just her face. All you would see is her. Wow, not very interesting. At least at the core, someone got hurt, right? Mr. McGarrell got hurt. You're smiling. Do you know?
I'm not smiling.
Do you know that my client is seriously and permanently injured?
There was an incident. There was a fender bender. And then there was another incident on the other side of our vehicle.
Okay, but do you appreciate that this lawsuit is because Mr. McGarrell says that he is seriously and permanently injured from that accident?
I guess. I don't know how you want me to answer that.
Would you consider, in general, one of your employees seriously and permanently injuring someone a safety issue?
If they seriously injured a person, yes, that is a safety issue.
Now you see, this is a great clip because she's rolling her eyes. She's making fun of my client who's seriously injured. But if you just had her head, you wouldn't see the interaction. You wouldn't see the emotion, the humanity of that moment. But by using split screen, it's like the jury is there in the room with you. Just like if this person was going to come live at trial and the jury would see that interaction at trial. So how do we get this real world and bring it into the virtual world? In the real world, you would do this with two cameras. You would have one camera on the questioning lawyer, one camera on the witness, first one on the witness, one on the lawyer. The same cameraman that's on the lawyer would record an exhibit that I might use, or if I build a chart, he might record it. And you'd end up with two video streams, the witness and the lawyer, or the exhibits and visuals. So you'd have, the lawyer and the witness. You would have the lawyer and the witness. You might have the witness in an exhibit. You might have the witness in a chart. So how do we bring this into the virtual world? Well, it's easy. Zoom does it for us. I mean, Zoom basically allows you to create 3 different video streams just built into the Zoom platform. One of the witness, one of the lawyer, one of the exhibits and visuals. The court reporter will pin and record the witness. Your office can pin and record you, and then you can edit it next to each other. You can edit it where you have the witness and the exhibit. And so here's another example from the drowning case that I'm in trial in right now. Did you know that Orange County had a specific form that effective January 1, 2015, they wanted filled out in near drowning or drowning incidents?
No.
Okay.
But
You've never seen a form that came from Orange County that was an incident form. So I'm running out of time, but you get the concept. You can split screen with the witness and the exhibit. You can split screen with the witness and the lawyer, and then you can mix it up. You always want to have the witness on the screen because most states have rules that the jury has to be able to see the deponent at all times. But the other side of the screen is for you to play with. visuals, documents, you, whatever is human and interesting about that experience. All right, tip number 5, agreement charts. It is getting the other side to agree to your safety rules in a way that cements your safety rules for the jury. So, for example, in the traumatic brain injury case, one of our safety rules is that safety starts with management. If management knows they've got unsafe employees, they've got reckless drivers that are driving their heavy trucks, they need to step in and do something. So I created an agreement chart. Safety starts with management, and then she was going to have to agree, strongly disagree, all the way to strongly agree. Don't put something in the middle that's neutral, because I'll always choose neutral. You know, make it to where they have to choose agree or disagree. We heard a lot about you, that this is your company, correct?
Yes.
You are the owner.
Yes.
You are the president of the company.
Yes.
Okay, president. And the buck stops with you.
Yes.
All major decisions are made by you or authorized or approved by you.
Yes.
You would want people to, if they see something, say something.
Exactly.
You would want them to report.
Yes.
And safety starts at management. When you get that report, you would expect your managers to respond.
Yes.
Fix the dangerous situation, correct?
Yes.
And Exhibit 2 says safety starts with management. I've given you a Sharpie. Can you tell me where on my scale you fall in agreeing or disagreeing with that statement? Safety starts with management.
Can I do this?
Sure you can.
Okay. I would say strongly agree.
And so I had her sign it and check mark it, and I put an exhibit number on it, and I attached it to the deposition. That's in the real world. Okay, so how do we bring that into the virtual world? Well, the same thing. You have the water park supervisor on the stand, in Zoom. You pick up your tablet with your stylus, and you ask her, children's water parks must put safety first to protect the children. Where do you fall on this scale? And when she tells you she strongly agrees, because she looks like an idiot if she doesn't, then you circle it and you put deposition exhibit number 4 on it. And at the next break, you screenshot this, put it in the chat or email it to the court reporter, and it gets attached to the deposition. Now, this is a beautiful visual to blow up for trial. It can be in your opening. It can be in your closing. You can cross her with it when she comes live at trial, because you've now established one of your safety rules through an agreement chart with the person. You've got their face, you've got the date of the deposition, you've got the logo, you've got the simple definitive statement, children, water parks must put safety first to protect the children. And then you have her choose what she's going to do. Out of time, but I wanted to at least get a moment to just talk to you face to face. Corporate rep depositions are some of the most exciting and important depositions you're going to take. This is probably going to be your first witness at trial. This is probably going to be the adverse witnesses that you call right at the beginning to prove up your misconduct, to prove up your motive. So you need the documents. You need to think visually. You need to decide what is going to be your safety rules so you can create your agreement charts. You need to think about getting different video streams so that you can edit in split screen when it comes time to play this at trial. And most importantly, go out there and have fun, because we're coming back after the pandemic. I'm in trial now. In just a little bit, you're going to be back in trial. We've got to start thinking again about what it's going to be like to be persuading juries and to be standing in the well of the courtroom. Nice to see you. Goodbye.